Over 10,000 rape cases were opened with the police between July and September last year, while the police's Family Violence, Child Protection and Sexual Offences Unit arrested more than 4,300 perpetrators of crimes against women and children during the same period. Despite the apparent increase in reported cases involving sexual offences, there are 31,499 names on the National Register for Sex Offenders. 511 names were added in 2021 and 211 names added onto the register last year. A total of 7,055 names are yet to be added to the register. But some civic organizations say these numbers don't add up when looked at against the prevalence of sexual violence in the country.
No, those figures do not make any sense. But at the same time, what you and I need to consider is that it is only upon conviction of a sexual crime or a crime being committed that a person's name would be entered onto the sexual offences register. This implies that it is not automatic and that it is a mandatory or administrative process that needs to take place whereby a court needs to order that this person's name be added onto the register.
Currently, the list is not public, although schools, creches and hospitals have the right to check that a person being hired is fit to work with children or mentally disabled people.
The idea is to protect children from criminals, especially convicted offenders. So the names of convicted offenders, those who committed crimes against children, will be put on the register. So the register is there to protect children.
There have been calls for the list to be made public to name and shame convicted rapists. Both Solomon and Warner say this is dangerous and would have an impact on the victim as well.
The difficulty in achieving this is that the name of both the perpetrator or offender and the victim gets added onto that register. And so it is not as much about protecting the right to privacy or protecting the information as it relates to who the perpetrator or the offender is, as much as it is about making public the information of the victim. And so it is quite complex.
Warner says in order for a name to be added to the list following conviction, the entire process has to be followed through. The ministry says it has experienced challenges in this regard. It also cites delayed sentencing and failure by a presiding officer of the court to make an order of entry of the information of the offender onto the registry after passing judgment. The ministry acknowledges that in some cases there is a failure on the part of the court to sign the conviction order or capture all the information necessary.
For a little bit more on this, we're now joined by Ntombizodwa Matjila, who's the Registrar of the National Register for Sex Offenders in the Department of Justice, Correctional and Constitutional Development. Thank you so much for joining us. Welcome to the program.
Thanks, Peter. Thanks for having me.
All right, let's start at the beginning because I think there's a little misunderstanding about who actually gets onto the register. It's not every person found guilty of a sex offence, is it?
Yeah, in the previous dispensation before the Amendment Act, you would have those who are convicted of committing sexual offences against children and persons with mental disabilities. But now, after the implementation of the new Amendment Act, you will have all convicted sex offenders. And the date of implementation of such took place on the 31st of July 2022, last year. So you will see now the increase in the convicted or in the registration of convicted sex offenders, because now we are actually including everyone that is convicted of a sexual offense against vulnerable persons. Like a list of victims that we used to protect has been extended to include other groups of vulnerable persons.
All right, so everyone who committed a sexual offence before July 2022 will not be put on this register. Is that how it works? So it's only people convicted after that date?
Yes, that's correct.
All right, okay. Has this register been working? Has it been doing what it's meant to do?
Yes, it has been. But I think the challenge in this instance is when we look into who we were protecting, or those victims that we are protecting in the previous dispensation, which we were looking into convictions against children and persons with mental disabilities. As far as that is concerned, it has been working quite well. And I think the challenge in this instance is when you look into when people are saying, why not register everybody else that has been convicted of committing a sexual offense against the child, which we have listened to the public and are now registering every convicted sex offender, irrespective of who they have actually violated.
People are saying that the numbers are not adding up. The people that are being arrested, convicted, is not equal to those in your register. What's going wrong?
The numbers could not add up based on the reasons that I've provided. But now you should look, because it is all convicted sex offenders that are supposed to be included in the register.
Yeah.
When you convict 1,000, you will then have 1,000. But in the previous dispensation, when you convict 1,000, but only convict 50 against children and persons with mental disabilities, you'll only have 50 appearing in the register. But now, because we are registering all convicted sex offenders, you will see the numbers starting to tally up. But I also need to correct that as well, because the numbers that we have, which are active offenders currently, is 31,556. And those that we have flagged, which means it's 38,758, meaning that the flagged offenders, when you begin with your introduction, those are the ones that are potential sex offenders, wherein we are currently waiting for the courts either to make an order or the orders to come to us, because without an order having been made by the court, we are unable to register those convicted sex offenders. You will see also, even in the current dispensation after the amendment, if the court hasn't made the order for that particular offender to be included in the register, we cannot include that until such time the court makes an order of inclusion in the register.
Are you happy that everyone who commits an offence of a sexual nature is going to be properly registered? I'm just thinking of someone gropes a woman's breasts, perhaps. If the police officer doesn't write a sexual offence, it might just be deemed to be assault and therefore doesn't get in the register.
Sexual assault, it's a type of a sexual offence. Even if you intimidate me and I feel that the words that you have said against me amount to sexual intimidation, I can go and report such to the police, and then when convicted, you will be convicted similarly to the one that has committed a violent sexual crime. So I am actually happy to see that all sexual offenses or all crimes that are regarded as sexual offenses are going to be included in the National Register for Sex Offenders.
All right. Who is a vulnerable person?
A vulnerable person over and above a child and someone with mental disabilities. We're having all women or young women under the ages of 25 who are attending the universities or any institution of high learning. We have the older persons who are 60 years and above. We have over and above the mental disability. We have now recognized all forms of disabilities. It can be physical, it can be sensory, it can be mental or otherwise, because the only disability that we recognized previously was only mental, but now we have taken into account all forms of disabilities. And we're having also those that who are receiving, or those who are in an institutions that is offering 24-hour care for people who are ill, people who are sick, people who are mentally disabled, and so forth.
All right. What's the time lapse between a conviction, the judge hits his hammer and says you're guilty, to when you update your register?
It's an immediate action. For example, if one is convicted now and the magistrate or the judge says, I am convicting you of committing a sexual offense against a vulnerable person, and I am actually making an order that your name must be included in the National Register for Sex Offenders, that is immediate, because we've got a system that is called an integrated case management system that takes into account what happens in court. And when that happens, you will have an official or the clerk of the court that is including that information in the register. And at the click of a button, it is forwarded to me until such time when I receive the original documents. So between the conviction as well as the sentencing, it depends, especially with the sentencing where the judge will then impose the sentence. It depends, but as soon as the conviction is made, that information is forwarded through to me, and then it's going to be pending, which means when we say it is reflecting as pending, we are waiting, obviously, the finalization of the sentencing as well as the submission of the original court order for us to activate it on the register. But from the conviction until my office, it's an immediate action.
All right, we've run out of time, but maybe you can answer this question quickly. There's a whole thing about disclosure. Women feel vulnerable, and they'd love to be able to check if somebody's behaving awkwardly, to check whether this person doesn't have a record. It could save a life, some might even say.
Yes, I agree. We have actually included that in the amendment, where we are allowing now every person that seeks to know by way of application whether or not the details of any other person of interest appear in the register. So you can apply, and then we can disclose whether or not that particular person is in the register. But that has to be in the interest of a vulnerable person when you do that.
All right. We'll leave it there. Ms. Matjila, thank you so much indeed for your time. Thank you.
Thanks for having me.